Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hi, and welcome to our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. Today's topic is, how do you get to the final yes? The art and science of settling antitrust class actions. My name is John Roberti. You know, in our antitrust bar, we find that there is lots and lots of litigation, but we also find that there are very, very few trials. And the reason for that is that most antitrust law cases end up settling, and most class actions end up settling and being approved by the court. And the reason for that is that there's risk on both sides, and generally people don't want to take that full risk. The problem is when you have two separate sides who see things differently and are coming at it from different perspectives, it is hard to get to that common place. Today, we're going to consider some of the issues and some of the ways that people can successfully settle antitrust class actions. My co-host today is Anora Wang. Hi, Anora.
Hi, John.
Anora, what are we doing today?
Today, we're going to learn how antitrust class actions settle and what's involved in the process and what some important actors and tools are. And
why is this important?
Well, as you already alluded to, a high percentage of antitrust cases are settled eventually, and a high percentage of antitrust damages are obtained through class actions. And given those two together, large amounts of money would be involved.
Well, who's our guest?
Well, our guest today is Megan Jones, who is a partner at the law firm Hausfeld, with almost 2 decades of experience in antitrust class actions, focusing on recovering damages for companies who are victims of antitrust cartels for price fixing, tying, restraints of trade, all sorts of fun stuff. And Megan is also on ABA Antitrust Law Section's Global Private Litigation Committee.
Great. Well, let's bring her in. Megan Jones, welcome to the program.
Hi. Happy to be here.
Welcome, Megan. So, as John already gave a great introduction to, what would be involved in a class action? What are some essential elements into a settlement agreement process, I guess?
Well, clearly, the settlement agreement itself, which is usually the result of arm's length, long negotiations. But once you've achieved that milestone, you clearly want to establish a preliminary approval brief and file that. That's the introduction to the court. You want to consider whether state attorneys general are required to have CAFA notice. It's a key element within 10 days of a preliminary approval brief being filed. The preliminary approval hearing itself, which is becoming more and more common these days. Final approval brief and the final approval hearing. But from the plaintiff's perspective, I always say, don't forget your FAN. And what you don't want to forget is your fee brief, your allocation brief, and your notice brief, which are all 3 other additional milestones that you need to make sure the court has in order to approve a settlement. So with the fee brief, obviously that's required for plaintiffs who are working on contingency and are going to apply for some portion or percentage of the fund. The allocation plan is how you're going to actually distribute the funds to class members if you're not doing it pro rata. And then the notice plan is how you're going to let the class members know that there's a settlement. So are you sending out direct mail? Are you sending them an email? Are you doing publication notice in publications around the world, around the country, in certain regions? What language you're going to use, what graphics you're going to use, any communications with the court, with the class members, have to be approved by the court.
Certainly, a lot of elements are involved, and it could take long, right? Just so that our audience have a better sense of the process. How long, on average, would such a process take? Couple years, month?
I think it it depends on the scope of the publication notice, which obviously you have to buy the advertising, run the advertising, conclude the advertising. So I think with direct mail campaigns and no publication element, it's much shorter. If you have a publication element part of your notice, it's longer, and it's going to vary based on the plan that you submit to the court. I would say a simple publication plan is 4 months, more complicated 6 months. So that would be in between your preliminary approval brief and after and before your final approval brief. So it can take anywhere from 4 to 10 to 12 months to get a settlement approved. It's obviously dependent on the case.
Yeah, exactly. And then timing, I guess, given what we have talked about, the length of time that would be needed to get to the final approval, it's probably a critical consideration, right, when parties are considering settlement.
Yes, I think that it does matter what stage in the litigation that you are about how that impacts the value and the feasibility of settlement. For example, that you definitely have to consider where you are in the litigation. From a plaintiff's perspective, early settlements are very valuable, or can be very valuable if the settling party is willing to provide cooperation as part of that settlement. It can have a commensurate lowering of the dollar amount because the value to the class is showing how the value of showing the inner workings, so to speak, of the case. That's very valuable to plaintiffs who are usually in an asymmetric situation. We don't know what's going on. We don't know the industry. And to have a guide to come in and say, this is the market, these are the distributors, this is how it works, these are the ingredients, and by the way, if it's a cartel case, this is when we met, and this is these are the actors. It can also impact settlement based on key milestones in the case, before class certification versus after class certification. Unfortunately, I've had defendants come and try to settle a case before class certification, walk away from the table. I win class certification, and they come back and say, we'd like that deal that you offered before class certification. And often that's not available. Mm-hmm. One of the things that I'm very clear is whether an offer from my side of the table has an expiration date, or if it's dependent on where we are in litigation. I think it's very clear to have those kind of expectations set. Conversely, right, the reverse is true. Mm-hmm. My settlement may be adjusted if I lose a key motion, or I lose a defendant, or as we all search for emails and texts and WhatsApp messages, I lose, for example, a key evidentiary ruling. I have the smoking gun, but I can't get it into evidence. That will affect my settlement negotiations and my posture. And so I think the timing can absolutely matter. I also think that in terms of timing, it's a very key to make sure you do things in the right order when you announce a settlement to the court. I've already mentioned CAFA notice. It matters because you file your preliminary approval brief, and it's the defendant's obligation to file CAFA notice within 10 days of the preliminary approval brief. If that does not occur, nothing else in the settlement can occur until that is completed. I think the regulations are 90 days. You cannot have final approval before 90 days after you send that CAFA notice out. And it's an unpleasant surprise to get to a final approval hearing and find out a defendant thought they did it but didn't. And so, the timing matters in terms of certain things have to occur in a certain order.
Right. So the order or the sequence of events definitely matter. And then I certainly don't want to simplify or attempt to simplify the things. But if we have to guess, like in a general direction, is there a right ballpark, right time frame that's the magic time to settle? Is there such a thing? And how would a party know?
Well, I think that for me, litigation settlement is really about evaluating risk. And so I think that the best settlements are achieved when there's clarity on the litigation risk in the case. And so Can I sit here today and tell you when that is? No. But I think that the ability to not only see your side, but the other side of the case is critical to having a meeting of the minds with an adversary. And I think that what I've seen, the most productive settlements are based on a give and take with the opposing counsel.
See, Megan, I'm going to disagree with you slightly on this. And I think the best time to settle is when nobody really knows the outcome of a particular event.
Spoken like a true defense lawyer.
The uncertainty that goes into it actually creates an opportunity for the two sides to assess that risk.
Right.
And the further you go down the road, actually the harder it is, because the level of uncertainty shrinks and the expectations kind of change over time.
I think that's an interesting point of view, but I think even the knowing when a case is uncertain requires a certain level of cognizance of what you have in the case, right? So if I have a defendant who I may or may not be able to have jurisdiction over, that's uncertainty.
That's fair.
But I have to be able to spot that issue.
And I guess where I was going was, the day before the ruling comes out is probably easier to settle than the day after. Because
right. I totally agree. I mean, the timing matters about the milestones, before or after class cert, before or after trial, before the jury verdict comes back.
Right.
All key. Right. And it goes back to that point of, when defense counsel think a deal is on the table for the entirety of the case, that's just not normally the case because of the uncertainty becomes there's less and less uncertainty in the case.
So in my experience, we often will kick off, and so maybe I hope I'm not sharing my secret sauce here, but whenever I go into any sort of case with any client, the clients are asking me, how do I get this done? Mm-hmm. Once in a while, the clients will say, on principle, I want to fight this to the end. And those are wonderful clients to have. But
we disagree.
but most clients are just saying, okay, we get it. There's risk. Help me assess the risk and help me get the most advantageous deal. And so going into the project, I'm just thinking about, how do I do that? And so what I'm thinking about is, when are there points in time when I can go and approach and my leverage is going to be the greatest? And we'll go and we'll try. And if we're too far apart and we can't make progress, we separate for a little while. And I look out in the calendar and say, well, when's the next point in time when something will happen that will give the sides a little bit more knowledge about where things are and potentially where my leverage would be?
I totally agree. And, a bad settlement discussion doesn't always necessarily have to be qualified that way. Oh, we didn't reach a deal. It was not productive. I don't see it that way, for precisely the reason that you identified. If you and I can't agree on what the product is, or what the statute of limitation is, or what the legal standard ruling is, let's go back to litigation, figure it out, and come back and talk.
And maybe we don't even have to get the ruling, right?
Right.
Maybe what I need is to share with you some information.
Right. Or I need to take a deposition,
right,
and I'm going to get clarity on that issue.
Right. And so, I mean, for me, actually, that's why I say, for me, the uncertainty is actually the time to really get it done. The other thing is, as you go through time, people need to take a journey. Right?
Explain.
Well, very rarely, oftentimes on the plaintiff side, somebody will have worked on a case and they think it's super interesting and they love the theory that they've come up and they're kind of in love with what they've done. On the defense side, they say instinctively, well, we didn't do it.
Nothing to see here.
Nothing to see here. And over time, people have to take the journey to say, okay, on the plaintiff side, okay, maybe this is not quite as perfect as I thought it was. And on the defense side is, maybe this isn't as perfect as I thought it was. And having those bad discussions sort of set the goalpost. And then it's just from there, you typically move closer again, unless you are at a milestone and the field changes. And then you have to.
Right. Well, because we'd be in trouble if that was the case, right? Because there aren't that many milestones in an antitrust case. You have class cert, you have motion to dismiss, you have a summary judgment motion, and our cases last 8 years. So typically. And so I agree that often settlement can help frame the issues that litigation can solve. And so you can go back to litigation, get clarity on your own side, assess risks on your own side, and then come back with a more nuanced view of your case.
So I'm going to also ask you a question, and it's probably not fair, okay? But just prepare yourself emotionally for that. As I've observed how some plaintiffs approach it, and given our joint and several and treble world, in a cartel case, some plaintiffs will say, okay, if there are, say, 3 or 4 or 5 defendants, defendant 1, you get the funding place. So you do it. You go first. You cooperate. You fund the case for me, and you get a good deal. Numbers 2, 3, and 4, you'll get increasing deals depending on how you go. Number 5, I'm going to save you for last. And you generally aren't choosing the ACPARA recipient, but it's generally somebody who's going to be subject to joint and several and treble. And you're saying, okay, you're last. Guess what? You look at this big avalanche that will fall on you. How does that play out? Do you choose? Do you pick people off one at a time? What's the thinking around that?
Well, I mean, I think obviously, by nature, right, in a multi-defendant case, people are going to settle in an order. So I can't. I think that's fair. The first in, we've talked about that, provides value. I think that joint and several, there's a reason why our antitrust laws were premised on joint and several liability. There is a deterrent factor. It is supposed to encourage good conduct and good corporate responsibility. I think that there's a timing element involved in your question, because it's usually not in a compressed time frame, 1, 2, 3, 4 fold, and then 5 is left. It's usually over a span of years.
Yeah, that's
and
right.
There's an entry point for settlement at any point. So, there is a choice by defendants as well. You wanted to wait to settle until after the 150th deposition. That is your choice. And that is going to fuel my value of the case. I mean, a good settlement evaluates risk. And no one knows risk better than a contingency lawyer. I don't get paid any of those years unless I settle the case or win at trial. And so it behooves me to become a specialist on how to evaluate risk and how to evaluate success. And so it does make it easier if I have previous settlements, because I have cooperating witnesses. I have someone who can help me get my documents in. I have someone who can explain the industry to me and give me data that usually is hard fought.
I'm sorry, Anora, go ahead.
Oh, I just want to maybe shift gear a little bit. We talked about all these hard work that we lawyers do, but there's certain other actors are involved in the process as well. Can we maybe shed a little light on what the courts do, and I guess some other, you would mention special masters later, but let's start with the courts.
So I think that's a good point to address, because settlements are an art, not a science. See previous conversation, right? The court and the litigants are going to have to carefully draft a settlement agreement that's appropriate for each case. And the role of the judge is important to, as a third party, neutral, as an Article III judge, to kick the tires of what is brought before her or him. And so, I think that Rule 23 was amended recently, and the rule drafters were clear in stating that giving notice is an important event and should only be done if there's a solid record supporting the conclusion that the proposed settlement will likely even reach final approval. And so I think the role of the court is enhanced to, at the preliminary approval stage, really ask questions. What supports your number? Which defendant is settling? For what years are you settling? And parties seeking that approval have to be able to put up or shut up. They have to show that that the settlement is fair, reasonable, and adequate. What's interesting is that in the committee notes make clear that defendants can join in this process at the preliminary approval stage without penalty. And if you actually check the notes, a defendant who says, this is why I entered into this settlement, this is the risk that I had, you can imagine as a defense lawyer, it may not be a comfortable position to say why you settled for this amount in open court. It's uncomfortable.
Well, it's I think it's equally uncomfortable for the plaintiff, right?
Sure,
because say, look at the 26 rates to you other defendants.
Right.
These are the risks I think I have.
Right. So in the notes it says if the settlement is not approved, the parties' positions regarding certification for settlement should not be considered if certification is later sought for purposes of litigation. And so I think that the courts are expecting us to come in and show the basis for the settlement, and also have some protection if it's not approved.
So, Megan, I've been married. It'll be 20 years, and then and now, my mother likes my wife more than she likes me. And when we were getting married, my mother told my wife very kindly asked my mother, "What role would you like in the wedding?" And my mother told her, "I'm going to wear beige and stay out of your way."
Solid.
That's kind of, as a defense lawyer, that's kind of what I do around the preliminary approval.
Yeah.
I mean, am I wrong? Should I wear a brighter color and dance a little more at the wedding?
I think that the game is changing a little bit, and it may be that you want to give talking points to the person on the stage. If the plaintiff's lawyers are not doing enough, you may want to join that conversation or shepherd it to a conclusion, because you definitely want the benefit of the bargain. You want the settlement agreement approved. And so,
yes.
Right? It's not a desirable outcome to be like, okay, we agree to settle, and then the court doesn't approve it.
And let's go back
and
now.
Right? That's not fun. And so, I think that there's a encouraged cooperation that the committee drafters have by necessity included in the rule. And I think because of the presentations that we're going to all have to make, I think, to help courts feel satisfied that the settlement is fair, reasonable, and adequate, we're both going to have to get out there and explain the benefit to the class members.
When a judge looks at the settlement, she might say, I think she's looking at a bunch of issues, but I think one of the issues that worries judges the most is is the allocation of the money, is enough of the money going to class members as opposed to going to other places? Has that been your experience, and how do you deal with those type of things?
Yeah, I mean, I think that I'm heartened by the judges that I've encountered having a holistic view of what a settlement should be, right? Hindsight is X-ray. It's very easy to say what you should have done, or how the case is going to turn out 5 years after it's over, right? That we all wish we had that kind of superpower. But you have to settle the case with the facts you have. And so I think most judges are cognizant of that when they evaluate a settlement, and where you are in litigation, what risks you have, how far down the road are you in discovery. And so I think that it's not always about just how much dollars did you get. I think that obviously matters, right? It's part of the rubric of what the judges advocate or approving. But I also think it matters in terms of where you are in litigation, what this certain settlement can provide for the case, and other factors are involved as well.
I want to ask you another question as well, and this is about opt-outs. How do you deal with sequencing settlements with opt-outs? Or I guess from the defense side, you worry, if I settle with the class first, that becomes the floor for every settlement that I do subsequently. What's your perspective on that?
Well, when I'm involved in a case as co-lead counsel, I pride myself on getting settlements that provide real value to the class. And so if you do your job right, you can minimize the risk of opt-outs. Sometimes it's just the nature of the case or the industry. If the class members are well lawyered. You're going to face it. I think that antitrust cases are hard and expensive and long. And so I think that the ability for someone to just come in a case and opt out and achieve what the class has done is harder than it looks. And so I think that, and particularly if you're in a sophisticated industry, it's not a commodity product. And so I think that the view that it's the floor for everything that I'm going to do after may be simplistic, because I know what I pay my experts and how much it costs. And so, in those conference room moments, right, with the opt-outs, there's an ability to say, what's your basis? What have you done? And I know how I'd handle that negotiation if there wasn't some there. And so, while I think that looking at a negotiation just from the perspective of everything else is going to be plus one it isn't necessary. Because the thing that I view as the most important step of a settlement is preparation. I don't want to go into a conference room without mastery of the facts and where I am in litigation. And I think that it's so important to to respect my adversary's time when I enter a settlement agreement, to know what I want to accomplish with this specific defendant. And so in the opt-out scenario, I think that the preparation for the realistic expectation of litigation can be a leavener.
And last question for you: how do you feel about objectors?
So I think that objectors can play a valid role if there is a substantive flaw with the settlement. I'm not going to paint all objectors with a single brush. However, there are it is a term of art of serial objectors, and their briefs are the same, and sometimes they forget to change the name of the case. And so, I think my opinion of the objector is dependent on the quality of the objection. And I'll harken back to preparation. If they've looked at my settlement and they have found something that I missed for whatever reason, that is one thing. And if it's something that's boilerplate and I've seen 185 times before, I have a different reaction. Do objectors ever call before you get that boilerplate brief? Not in my experience.
All right. Well, this has been great. Let's shift gears a little bit. Megan, look, it's obvious you love what you do. What's fun about being a plaintiff's antitrust lawyer?
Every day, I'm putting together a jigsaw puzzle. I am taking facts. I am taking law. I'm taking economics, and I'm putting it together to meet my burden. And I find that endlessly interesting. My happiest place is in the documents. I'm one of I know, the quizzical look on your face. It is my joy to be on the hunt for the perfect document that will help me put everything together. I love it. I love a binder. I love looking through documents. I love putting the case together from the ground up.
I just heard you say I love a binder.
Yeah.
Well,
hashtag fact.
Well, Megan, tell us something interesting, unusual about yourself that we wouldn't know about you if we only knew you professionally. Besides that, you love binders.
I mean, I love being able to put together a case. And it always starts with a binder of like 500 documents, and then it becomes 50, and then it becomes 20, and then I've got you. I think what's interesting, or something that's unknown about me, is I basically live in an airport. I'm in an airport a lot for my cases. And I view it as my moral responsibility to help any parent traveling alone. I've been that mom often with the stroller that won't unlatch, or I've got a baby in my arm and I've got to reach the, overhead.
Right.
And so as an unencumbered business traveler, I'm on a plane a lot. And so I look out for anyone that I can help and lend a helping hand.
So I try to curb my instincts on that, because I'm the guy who's behind the person who doesn't know how to figure out how to do the TSA pre-check thing and is taking off their shoes, and I'm just looking at them saying, "Come on now."
Oh, right.
But then I think about with my kids, we've all
been there. Yeah.
So I try,
and so we're just in the airport going to our depositions and our hearings, and it's lovely to be able to make someone's day a little easier.
All right. Well, let's go to our last segment, which we call the Curious Hat.
And now it's time for the Curious Hat.
In my left hand, I have an actual hat that has actual questions in it. I'm going to hand the hat to Megan and ask her to pick a question out, and that will be the question that we ask her. Okay. Megan is picked question number 8. What is your perfect weekend?
It definitely starts with no plans. I like an unscheduled weekend. Diametrically opposed to my son's sports schedule. But what if I'm driving? Coffee, reading, a good dinner with friends, at my discretion. No plans.
So interesting. My weekend is pretty much the same. I actually have a job as a dedicated driver for children, and and that's kind of what we do on weekends. It sounds like you, like I, they accuse me of being two-dimensional.
Yeah. So the best day is when I open up my schedule for a Saturday and there's nothing on it.
Let's you and I commit to getting a hobby.
I mean, I'm going to read, I'm going to go see friends, I'm going to have coffee, and but I don't want to have to do anything.
Mm-hmm.
Well, with that, thank you, Megan Jones. This is another episode of Our Curious Amalgam. We will see you next time.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.